It is Indiana in the Morning, presented by First Commonwealth Bank on the Voice of Indiana County, WCCS 101.1 FM and AM 1160. And it is time for an interview segment presented by Marcus and Mack, a law firm representing injured people. But we have with us on the phone right now a pretty good guy. It is Marshall Chriswell with our Martial Law segment. Now, before we get started, we will say this radio program is intended to be for informational purposes only. This information does not constitute legal advice. The law is constantly changing, and the information may or may not be complete or correct depending on the date and your particular legal problem. Each legal problem depends on its individual facts, and different jurisdictions have different laws and regulations. Because of these differences, you should not act or rely on any information in this segment without seeking the advice of a competent attorney licensed to practice law in your jurisdiction for your particular problem. Again, joining us on the phone today, Marshall Chriswell. Marsh, it's good to hear from you again.
Good morning, Josh. How you doing?
Doing excellent, sir. Thank you very much. So today, you mentioned the topic and the song popped into my head. I'm sure you know which one I'm talking about, but I'm just going to say it. It is divorce. So let's just talk about the nuts and bolts of it. I mean,
okay.
It can be at times a very long, drawn-out process, but I guess also it can be a very quick process, just depending on how things work, right?
Right, and we'll skip spelling it like they do in the song.
Yes, please, let's.
Right to the nuts and bolts.
Yeah.
Okay, so whenever a client comes to my office and is considering divorce, or they've been served with a divorce complaint from their spouse, there are some common questions that people have. One is, how long is this going to take? And also another is, what if my spouse doesn't agree? What if they just won't agree to a divorce, or what if we can't agree on how to divide our assets or other topics associated with the divorce? So at that point, I always take the client through the divorce procedure under the Pennsylvania Divorce Code and how it works. So there are three different types of divorce in Pennsylvania. One is a mutual consent divorce, also known as a 3301C, because that's the section of the divorce code it appears under. So mutual consent. There is a 3301D divorce, which is not with mutual consent, and there is a 3301A, which is a fault-based divorce. And all three of them are a little bit different.
Okay.
So if you and your spouse have agreed to the terms of the financial settlement of your divorce, generally we'll be proceeding under a 3301C mutual consent divorce. And to get a mutual consent divorce, number one, a divorce complaint has to be filed and served on the other party, and you have a 90-day waiting period. It doesn't matter even if you've agreed to everything far ahead of filing for divorce. It doesn't matter. The Pennsylvania legislature, in its wisdom, has determined that all divorcing parties need to have at least a 90-day waiting period before the divorce can be finalized. So there's that period, and then after that 90 days from the service of the complaint elapses, then if all matters have been agreed upon, we have a settlement agreement, the necessary papers can be filed to finalize the divorce. So that's the quickest way to get a divorce under Pennsylvania law, is by agreeing to everything, wait your 90 days, and get your divorce decree.
All right. Now, we'll pause right there on the nuts and bolts, but I wanted to ask a specific question.
Sure.
In your experience, and again, you don't need to quote any specific particulars, but have there been cases where people have filed for divorce and then have gone back on that filing and say, you know what, let's try to stick this out?
Absolutely. Under Pennsylvania law, when you file a divorce complaint, the attorney who's filing the complaint needs to inform the client that marriage counseling is available, There is a list of qualified marriage counselors that's maintained at the courthouse, and you actually put in the complaint that the plaintiff has been informed of the option of marriage counseling, and they've determined that they don't want to do that. And then the defendant, when they receive the complaint, they also have the option to request marriage counseling. And if the parties then can agree, okay, let's try counseling. Sure, absolutely. I've had many cases where folks have begun counseling and then decided, okay, we're going to withdraw the divorce, even after they're, sometimes a year or more into the process.
Okay, so that's actually pretty interesting and encouraging to hear, I think, in that case.
I agree.
Now, you mentioned the other two types of divorce processes. Maybe you can go into details on those.
Sure, the 3301D divorce. So this is a divorce that you can only obtain a divorce under this code section if you have been separated for at least 1 year. So if you Pennsylvania law has a specific legal definition for separation. Generally, it's when the parties begin to reside in separate households. But I have had cases where maybe it wasn't financially possible, or because in the best interest of the children, or some other reason, the parties decide to continue living in the same house, but they actually carry on separate lives. So if you're living in separate sections of the house, not eating meals together, those types of things, the court can actually make a determination. Okay, you didn't live separately as far as separate abodes, but your separation date was X, because that's when you started living separately in the same house. So the date of separation is very key for the 3301D divorce. And then as long as you have been separated for 1 year, either party can move to finalize the divorce. And so this is the section that you've got to use whenever, let's say you file your divorce complaint, you're hoping that that the parties can work everything out, that you and your spouse can work out the financial issues of your divorce and proceed with a mutual consent divorce after 90 days. But you can't come to terms. Either sometimes the other spouse just doesn't respond and doesn't cooperate, or the two of you, we talk, maybe we even have a mediation or settlement negotiations, and you just can't come to terms. So that's when this 3301D divorce kicks in. Once 1 year passes from the date that the two of you have separated, then either one can file a petition with the court to have what's called a divorce master appointed, which is an antiquated term for generally a local family law attorney that's appointed by the court to hold a settlement conference and eventually a hearing in your case. So neither party, the takeaway from that is neither party can move to finalize a divorce until 1 year has passed from the date of separation if there's no agreement.
Okay, so that's where we get sometimes the stereotype of divorce cases possibly going for a very long time.
Absolutely.
Okay.
Absolutely.
Now, the third instance of divorce, now, what is that? Because it seems like we've kind of touched on the differences between the first two. What's the difference on the third?
So the 3301A divorce is it has almost vanished from Pennsylvania law. It's still on the books, but there are very, very few cases filed as a fault divorce. What a fault divorce is you could file and you could say, all right, my spouse has engaged in such conduct that I should be granted a divorce immediately upon a hearing. And there are several grounds that are laid out in the statute for a fault divorce. If one spouse abandons the other, commits adultery, abuses or injures the other spouse, engages in bigamy, right? They get married to somebody else while they're still married to you.
Right, yeah.
They go to prison or mental institution for a term of 2 or more years. So all of these things can be grounds to file a fault-based divorce. But The reason that this is so uncommon is because to file a fault-based divorce, gather your evidence, get a hearing, get a judge's decision, you would almost be at the 1 year separation period anyway.
Okay.
When you can get it, and you can get a divorce without fault grounds after 1 year. So once the legislature moved, it used to be a much longer period, 3-year separation period, then it went to a 2-year separation period. Now it's a 1 year separation period before you can get a no-fault divorce. So the fault-based divorces have almost vanished from the court dockets.
Do you think that could ever be removed from the books because of its lack of use?
I don't know if it would be removed. There are still some cases where you want to file a fault-based divorce, but it's possible. If they lowered the separation period for a no-fault divorce even farther, or removed that separation period, certainly the fault-based divorce would become completely obsolete.
All right. If anybody has any questions about divorce proceedings, they should obviously contact a lawyer like yourself. And how can they get a hold of you, Marsh?
They can call me at 724-465-5826. Can always stop and see us in the R&P Cole building at 655 Church Street in Indiana, or go online to www.westernpalawyer.com.
Excellent. Well, it was a very interesting discussion this morning, Marsh. Thanks very much for joining us here on Indiana in the Morning. I look forward to hearing from you later on down the road with Todd.
All right. Okay, Josh. You take care. Thanks a lot.
You too, Marsh. Thanks again. Marshall Chriswell joining us for Martial Law this morning on Indiana in the Morning, presented by First Commonwealth Bank on the Voice of Indiana County, WCCS 101.1 FM, AM 1160.
Here are side effects of person 60. Here are side effects of person